All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good afternoon. We're here for oral argument in our case number CV24-0029, Martin versus Haynes. Counsel, remind you we're recording and live streaming the argument, so please identify yourselves and who you represent at the beginning of your argument. Each of you will have 20 minutes, but you're certainly not obligated to use all that time. Appellant's counsel, if you'll watch the clock and reserve as much time as you wish for rebuttal. Also, please keep in mind we've read the briefs, we've studied the record, and we have discussed the case in conference. And with that, counsel for appellant, you may proceed.
Good afternoon. May it please the court, Brennan Edwards acting as co-counsel for appellant father David Haynes. Today's oral argument stems from a May 10th, 2022 child support order and its interpretation, an issue this Court of Appeals reviews de novo. The May 2022 order orders as follows. As to child support arrears, no additional judgment for child support arrears is entered. As to past support, no judgment for past support is entered. And then the order concludes by stating, this further order denying any affirmative relief sought before the date of this order that is not expressly granted above. To that point, I believe the order portion of the child support order is clear. There are no arrears, and the parties need to be able to rely on the court's orders. I think the explicit language says that.
Counsel, sorry.
The court didn't make a finding that no arrears were owed, did it?
It did say that in the findings, however, in the actual, what it ordered, it says that there was no arrears ordered. And I know back in at the time when they brought the enforcement hearing, that court said that we need to look to what the court actually owed or ordered. But in that, they didn't really read any of that, and they also kind of browsed over that last global denial of anything that was affirmatively sought and that wasn't affirmatively granted.
Counsel, let me ask you a couple of questions on previous child support orders. So in 2016, the court issued a child support order, is that correct? And at that hearing, were arrears addressed?
I don't believe so.
Okay. And then in 2019, there was another child support order, correct?
It was.
And were arrears addressed there?
It was, but again, none of that language denying any relief sought that wasn't expressly granted was not included in those orders, if I do remember correctly.
Okay. The reason I'm asking is in the 2022 order, you began your argument by quoting paragraph number 5 and then the last order of the 3-page order. But order number 4 in 2022 says support arrears not addressed. And the reason I'm asking is because the exact same language is used in the 2016 order and the 2019 order where it says arrears not addressed. So that's my question to you is, were arrears addressed in those previous orders, or does the same language from the 2022 order that exists in the 2019 and the 2016, does it reflect the same thing that arrears were never addressed in any of the hearings?
Right, they all include that language, but again, the other 2 prior orders don't include the other language as far as, again, even in the 2022 court order at the end, it says no further claims or issues remain for the court to decide. Therefore, it is further ordered pursuant to Rule 78C of the Arizona Rules of Family Law Procedure. This final judgment decree is signed by the court and it shall be entered by the clerk. Even that language wasn't included in those prior orders, showing that all the issues before the court in that matter were settled, and that's where the ambiguity was between the parties, which is what they kind of argued later on in the enforcement hearing, that there was some ambiguity between what the court said and what the enforcement court found. The trial court and what the enforcement court ultimately found. And I think think that's where we are kind of like, after the trial, we should have addressed that immediately, whether it was motion to correct, motion to clarify the court's orders. Instead, neither party took, or both parties took the position that child support arrears was determined by the court, and then a year and a half goes by.
Mother took that position?
There was nothing ever brought forward challenging the court's rulings as to arrears until a year and a half later. She seemed to change her mind and file a few different pleadings that addressed that. But at the time, after the original 2022 trial, there was nothing showing that child support arrears were still pending. In fact, both counsel withdrew from the matter pursuant to Rule 9D, I think it was 9D2A, and in that rule, it basically states that there are no pending matters before the court, everything's been settled, and so both counsels withdrew, showing that both sides took a position that child support arrears was not an issue that remained pending before the court. If they had withdrew pursuant to if the court had ordered pursuant to Rule 78B, as to, if not all claims have been settled, I can see that argument. There was a pending issue of child support arrears. That wasn't the case. The court ordered that all issues before it in that matter were handled at the time of the trial court in May 2022.
So the arrearage was for child support that had previously been ordered and had accrued. It was a debt that was owed to mother. And so is it your position that by not addressing it, the court waived a debt that was owed to one of the parties?
No, so our opinion, so she makes a claim for 2012 all the way through 2023. And I think with that, you run into, in fact, you run into a promissory estoppel kind of argument, because you might have reviewed that there was an agreement by the parties back in February 20th, 2019 that said, actually, let me read it as it states. It states, parties agreed to deviate child support to $700 per month. However, the parties agreed to modify parenting time and child support if father changes employment. If father changes employment, parties shall attend mediation first. Thereafter, a petition to modify parenting time and child support may be filed.
Did the agreement address arrears, though?
The
Rule 69 agreement, did it touch on arrears?
It did not from when she says 2012 to 2019, it did not. But from that point on, that's what,
They agreed to a child support order going forward from that point
from
forward.
2019, February 20th, 2019, going forward up until now. And then shortly thereafter, Helen father, his employment changed. I believe it was March 29th, 2019. There was a current employment, current employment information order that was was entered by the court, showing that appellee wife had provided the court with his change of information, contact information for the new job, as well as their atlas number, the case child support atlas number, and then later on she filed a petition saying that that information was never provided to the court. Kind of goes against what she actually sent the court and what they entered.
Okay, but going back to my question, this is for child support that was ordered, it accrued, it was a debt that was owed to the mother, and your position is that the court waived the mother's debt by not addressing it at the hearing.
So we're going from 2019, when they made that agreement to address the child support, to 2023, because she claimed for 2012 all the way to 2023. And we're saying from 2019 to 2023, he was getting into my argument. There was no arrears because after that argument, after he changed his employment, he thereafter started paying her $200 a month.
What period did the arrears order in 2023 cover?
I believe it was, up to the date of the enforcement hearing. That would have been November.
When did it go back to? When did it start? When did the arrears start to accrue?
She had put in there 2012 to that point.
So the arrears order goes back to 2020 or 2012.
Yes.
What I'm hearing you argue, though, is from 2019 forward, there were no arrears that could have accrued?
No, because based on their argument, he was paying $200 a month. She was fine with that. She was taking that because of the employment, his change of employment. And thereafter, she's seeking to come back and get they had agreed for the $200, that was good. Things were good from 2019 until 2021.
But what about, to Judge Kiley's question, what about all the arrears that had accrued before then?
Our position is addressing the 2019 ones and onward, saying those are not valid. The ones from the agreement to 2023.
How much of the $8,900 in arrears plus interest addressed 2019 forward arrears?
I do not have that information from 2019.
But the arrears orders went back to 2012, is that right? The $8,900 in principal went back to 2012.
Yes.
And you're only saying a portion of that is not mother waived, or the court already ruled on a portion of that?
Not necessarily waived, but you run into a promissory estoppel thing because they agreed to go down from $700 to the $200 that he was paying and that she was accepting. And so to go back and then say, I want payment for the $700, even though we had this agreement,
So I must be misreading your brief. So how I read your brief is you're challenging the arrears order in its entirety, saying all of the arrears, the court previously waived any arrears mother owed because the court either expressly or impliedly, either argument you present, addressed it in 2022 by failing to expressly address it.
No, not the ones prior to that.
Not prior to 2019.
No.
So do you know what portion of the arrears you're challenging then? The dollar amount?
Not the dollar amount, just the time when Rule 69 agreement was put into place up until, I believe she claimed it until November 2023.
So you're saying that, sorry, just want to make sure I'm tracking. You're saying the Rule 69 agreement in 2019 effectively took care of any arrears up to that point. Am I following you?
No, it took care of ones from that point onwards. She's making a claim to get those arrears as well as the ones that go from 2012 to 2019, up until that, when they signed that Rule 69 agreement.
And so you're saying that Judge Pineda tacitly made a finding that no arrears were owed?
Right.
Okay, but that finding does not appear anywhere in her order.
Well, I think, and we also try to say that at the enforcement hearing, that I believe she dated the child support going back to just June 2022. Didn't provide anything, before that. And then the actual award was $230, very similar to what he was already paying her at the time, pursuant to their Rule 69 agreement. And that was part of our argument that that's why the trial court denied those arrears.
Do you want to touch base on your Rule 28 argument that the pleadings were somehow amended?
Yeah. Yes. So in the
Or the petition, mother's petition was amended? Because you'd agree in mother's petition, she didn't expressly ask for arrears, correct?
she brought it in the pretrial.
Right, in her petition, she didn't ask for arrears, correct?
I do not believe so.
Okay, and then she has a statement, one sentence in a pretrial statement that says, by the way, we need an arrears calculation, correct?
Right.
But I think your Rule 28 argument, if I understood your brief correctly, is that she testified at the 2022 hearing saying she was asking for arrears. Is that correct?
Yes.
And that testimony amended the petition. Can you talk about that a little bit?
Yeah, absolutely. Yeah. So we were just in that it was discussed at trial, and that's why they also took the position afterwards. There was nothing for almost a year and a half, even showing that they took that stance that it was settled. And going back to the Rule 28, and it says, when an issue not raised by the pleadings is introduced at trial by the parties express or implied consent, it must be treated in all respects as if it had been raised in the pleadings. The party may request at any time to amend the pleadings to conform to the evidence. However, failure to amend does not affect the result of the trial on that issue.
But don't we have at least a slight problem? We don't have the transcript of the trial, do we?
We do not, because at the time, that was not in dispute. The mother's position as far as child support arrears being handled by the court. That's why the transcript was not requested. There was no dispute as to that, and even at the enforcement hearing, we had raised that, and mother never denied that was her position.
But you understand if you're going to assert that something happened at an evidentiary hearing on appeal, and we don't have that to confirm that, then we have to presume that it didn't happen. And we can't take, you see what I'm saying, counsel? We can't take your word for it
Right.
that the issue was raised at the hearing when we don't have proof of that.
Right. Going back to the actual interpretation of the child support order, then wouldn't that would be reviewed de novo, not subject to the enforcement court's findings as far as
What the order actually says.
in the actual order part, it says that it wasn't ordered. The child support order
It says it wasn't addressed also.
I guess I'm looking more so at what was actually ordered compared to the findings of the court, the actual explicit language of, and as well as the global denial of anything not expressed herein is denied, basically.
Let me ask you one other question on Rule 28. So Rule 28 that you just read to us, I think it was subsection B you read, says that the parties, if they consent to the pleading being amended, then the court should amend it. What in the record shows us that your client consented to mother's petition being amended, or his petition being amended?
I think, presenting this argument, about child support arrears.
My question is, was there something, like, did your client testify at trial? Yes, Judge, I consent to mother's petition being amended so that we can address arrears.
Well, no, but the rule also says express or implied consent.
But by both parties, not by one party. It says parties plural. So both have to consent.
I think, by bringing this forward, the child support arrears issue to this day, if that's implied consent that we're trying to figure that issue out. If it was still pending, and that's their position, it is still pending, or it was still pending after the trial, the 2022 trial. I think bringing that forward, both parties, and we're here today arguing that same issue. I'm not sure if that doesn't, that's not implied consent as far as the child support arrears issue.
Can you clarify for me one more time? So the relief you're seeking from us is, can you nail that down in a couple sentences? It's the 29, you're asking us to declare that there are no arrears for 2019 to 2023. Is that
Because then you run into the problem, yes, you run into the problem of promissory estoppel because of the agreement. You can't, they agreed $200, making those payments, nothing happened for another 2 years. That's when her petition came. After mediation, they had agreed mediation as parenting time. They hadn't agreed to child support. However, from 2019 to 2021, making those $200 payments, you can't then go back and say, I want those, the rest of the money, that the other $500, and that was pursuant to the court order, the Rule 69 agreement, excuse me. So from 2019, February 20, 2019 to 2023, or the end date when she claimed that there were arrears still going.
Did you make a promissory estoppel argument in your briefs?
I don't believe it was in the opening brief.
You have 2.5 minutes. I don't know if you want to reserve any time for rebuttal.
Yeah, I'll reserve some time for the remaining time. If I have any questions.
Thank you.
Thank you, Councilor.
Good afternoon, Your Honor. My name is Edward Walneck. I'm the counsel for mother, the petitioner, Katie Martin, now known as Katie Jasperson. And we bring forward this case today to ask the court to deny father's petition that he's brought before this court. It's fatally flawed in many ways. That this court's questions just revealed, and the arguments I'm going to be discussing with you today.
Counsel, what period of time did the arrears order cover?
Your Honor, excellent question. It covered, and the court was explicit in the enforcement court, it covered from September 1st, 2012 to October 31st of 2023. And it's important to note from the transcript from that hearing, which was provided by opposing counsel, The court asked the explicit question on page 11 of the transcript to opposing, to.
This is at the 2023 hearing you're talking about?
Yes,
Okay,
Your Honor, the enforcement. hearing.
okay.
Is the arrears calculation correct based on my interpretation of the order? Opposing counsel for appellant father said, well, yes. If there's no arrears denied, then I don't know that it would be incorrect. The court said, oh, right. So at the enforcement hearing, it wasn't an argument that the calculations were incorrect, is what we're now hearing the argument today, and this promissory estoppel argument, frankly, is the first time it's been brought up in this matter. From my quick review of the brief, I can't find it in the opening brief, and I can't find it in the reply brief. I believe their initial argument was what they made at the enforcement level was that the entire amount needed to go away because there was an order at the 2022 hearing that denied it. And that's cherry picking by the other side. The court was right to point out that on paragraph 4 of that order, before anything else is stated about arrears, specifically states that support arrears is not addressed, and the rest of the order has to be read by that. If they're not addressed, there's no reason to issue an order on arrears. I would also remind this court that mother's petition that she brought before the court, there was 2 petitions. Mother's motion for, or petition for modification, and father's petition for enforcement for parenting time. We're not talking about parenting tonight. We're just talking about child support. Mother did not have a petition for enforcement in front of the court. This was just for modification. And with all due respect, Your Honor, there wasn't anything in the petition. And what we're talking about, the statement in the pretrial statement, that was not a request for affirmative relief. That was a statement of fact, that there were arrears. She didn't ask.
What about at the evidentiary hearing? Did she testify about asking for it as alleged? Is there anything in the record that shows us whether she testified to that?
There was nothing provided to this court. I haven't had a chance to review the transcript because the transcript was never produced by the other side. And I'm not willing at this point in the least bit to concede that she did bring it up there, because I think the Baker case, which we cited in our answering brief, explicitly states that it's on the duty of the appellant who's bringing this case if they're going to try to contend that there was an issue brought up at trial that's not reflected in the record, and that's what they're doing, Your Honor. And if they're going to try to say that there was consent given by both parties, they're going to have to bring up the transcript, because that's certainly not part of the orders from the court in 2022 from Judge Pineda. So, Your Honor, I would just respectfully remind the court that paragraph 4 and the May 10th, 2022 child support order is important, and that it specifically states that support arrears are not addressed. There's no order explicitly stating the arrears at 0. I think this court was right to center on the fact that the court issued no affirmative order waiving mother's debts. And this is important because the case law from this court has time and again demonstrated that child support is vested when child support becomes due. So as Judge Kiliat stated, did the court waive the debt? No, it didn't. It was vested and due during that time period. The McClanahan case, the Ferris case, and the Batterstadt case clearly show that this was vested and due during that time period. And again, I can't overstate the following situation that we just heard from opposing counsel and their argument to this court. They advocated that a Rule 69 agreement in 2019 somehow took care of future arrears. I don't think that's possible. How you can have an agreement deal with...
Did that agreement address arrears? Arrears by definition are past, but did it address past support owed?
Not to my knowledge, Your Honor. This court enforcement order in 2023 was the first time it addressed the orders arrears from 2012 to 2022. Or actually, it went all the way to October 31st of 2023. Every time before that, as Your Honor pointed out to the other side, is that it continually pressed forward that arrears are not addressed. Arrears didn't get addressed because it wasn't properly before the court. Every time they came and modified it, it wasn't being enforced. It wasn't asked. So it just kept on building up. And eventually, when my client properly brought a petition for enforcement, which she admits on the record she tried before and she filed the incorrect document, it was denied, and she finally brought forward the correct petition for enforcement. At that point, it was properly before the court, and the court could properly address that. And Judge Newcomb...
So, counsel, can you back up a little bit? Sorry, you lost me a little bit on the Rule 69 agreement. So when was that? In 2019?
I believe it was in 2019.
And what was its purpose?
My understanding the purpose was to modify child support at that time going forward.
Okay, so how would arrears continue to, are you saying there's new arrearages continuing to occur after 2019?
Well, the enforcement took place after that in the sense of...
Well, I'm not talking about enforcement, just like if you agree at a certain date and time for this date going forward, this will be the amount of child support. How is there a new arrearage? I'm not talking about the old portion.
Yeah.
How is there a new arrearage starting in January,
After
in
the...
after the Rule 69 agreement?
So I'm going to just make sure I give a comprehensive answer to this. So before the 2019 agreement, there was monies not paid. So
Understood.
I think we all
Right.
agree that...
And that's how you get an arrearage.
Yes,
Yeah.
and
So
the other side has conceded today that that amount is not, I guess, in effect. So part of this judgment is good. After 2019, there was an agreement, but part of that money was not subsequently paid by the appellant.
There was an agreement to monthly support going forward.
Correct.
Right.
That's what changed,
Correct.
as for child support.
Correct.
and husband did not keep up with the bargain.
Correct.
Okay.
So,
Do we know the amount of that roughly? I mean,
all I can go, Your Honor, is, in my understanding from the record, is in that, and I think it's important to say this, appellant's counsel at the enforcement hearing conceded that the amount that the court calculated was correct. They did not fight at any point during that hearing that the amount was incorrect, and even in the briefing, that's not an issue in front of this court that the arrearage was improperly calculated. That's found nowhere in here because it's not an issue before this court, and they conceded that issue, Your Honor. The calculation was correct. I believe that the amount... Court states that the principal at that time, from September 1st, 2012 to October 31st of 2023, the principal was $8,391.21, and the interest at that time was $1,928.84. And again, there was no dispute of that. They calculated that in a conference before the child support hearing, and the court, as I read on the record a few minutes ago on page 11 of the transcript from the 2023 hearing, explicitly asked opposing counsel, any issues with the calculation? I just want to make sure, besides you making this argument that the court already ruled on this issue, is there any argument with calculation issues? And it was explicitly stated at least once, maybe twice, that there are no issues with calculations, Your Honor. And the phrasing again, well, yes, if there's no arrears denied, then I don't know that it would be incorrect. And that's it, Your Honor. I don't think the amount is in dispute if the court agrees that Judge Pineda did not affirmatively deny arrears, and that Judge Newcomb at the 2023 hearing set that amount. Your Honor, I would like to finally address attorney's fees in this case. I think in family law cases, we too often ask for attorney's fees, and you probably see that in almost every appeal that comes before it. But there are some times when I can come up before you and legitimately argue that attorney's fees are needed. And this is one of those cases where it is. Because a father may argue that there was confusion and he didn't understand before he went in front of Judge Newcomb in 2023. Judge Newcomb clearly explained at that point why arrears need to be incurred. Almost ad nauseum in the hearing. He goes back and forth, back and forth. He explains that and does not assess father attorney's fees at that point. But nonetheless, after that explanation, father does not stop. He appeals, and we're here today on, my opinion, a frivolous claim and a frivolous appeal in which there's it's not supported by law of facts. They didn't produce the transcript. If that's what they were going to argue, there was either consent at the 2022 hearing, or they were going to try to argue something that wasn't there. They needed to produce the transcript. They didn't. In addition to that, Your Honors, in terms of having the financial ability, there's an AFI part of the record. I believe it's Internal Record 81 that clearly shows that father has the financial ability to pay attorney's fees for my client. So the request is made under ARS 25.
Counsel, is there also evidence in the record of your client's
Yes.
financial resources?
Yes. I do not have the internal record number, but the court does have her updated AFI. Because we're still arguing, Your Honors, below about a modification as we speak about child support. So they're updated AFIs within the record. So Your Honor, we respectfully ask the court to allow us to file a China Bell affidavit and allow the court to make a judgment on that. So in conclusion, Your Honors, we would ask that because of the accumulation of facts and operating the most important part of this is the child support order that came out on May 10th, 2022, explicitly stating that arrears are not addressed, hence no reason to issue an order, that the court did not address the arrears at that time, nor did it address it before, and it was properly in front of Judge Newcomb, and that he was absolutely correct to enter in the amount that he ordered in, and the amount, Your Honor, with all due respect, is not in dispute. The amount that he calculated because of what the other side conceded during that hearing is proper amount. It's also not before this court, and it hasn't been pled as relief by the other side. Your Honor, if you don't have any other questions, I will, for probably the first time ever, be done with time left. Thank you, Your Honor.
Thank you.
So addressing the point that opposing counsel said, as far as the amount of arrears addressed at the enforcement hearing, I mean, you heard there was no agreement. The agreement was, or the statement was, I don't know that it would be incorrect. I don't read that as I agree that you are correct.
Well, that was the opportunity to object if there was a problem with the calculation, right?
Yeah, but they're bringing that issue now, so I'm just rebutting. There was no agreement as to that amount.
But the accuracy of the calculation was not disputed at the trial court level, correct?
I don't know. They didn't really go into that except for that one line questioning.
Saying, I don't know if it's wrong means I'm not contesting that it's correct, doesn't it?
That's what I read. And then going back to what opposing counsel said, didn't ask for arrears in the pre-trial statement. I mean, the statement was an arrears amount needs to be calculated and added into father's child support application for retroactive support. I mean, that's asking, arrears needs to be calculated, asking the court right there. Mother wanted so essentially after the Rule 69 agreement, and then when she brought the enforcement hearing, she's saying from the time of the agreement to, I think opposing counsel said October 2023, she wanted the $700 in child support to continue after that agreement, the Rule 69 agreement, after accepting 2 years worth of payment from father, $200 a month, because he changed his income. I mean, that amounts to the $500 difference in arrears, 26 months from March 2019 to October 2023, March 2019 to April 2022, in the trial, it's about 26 months of arrears right there. As far as attorney's fees, we stated in our pleadings as well, mother was of the position that you didn't hear anything about arrears after trial. She also, I think she said that, I didn't have an attorney at the time. That's why it prolonged for so long. After trial, she did have her attorney for 5 months after that. Again, there was nothing said about arrears. Even after she states that she talked to everybody she talked to said these haven't been settled. Assuming that, she had talked to prior counsel as well. If that was the case, then she could have brought a motion to clarify or a motion to correct the trial court's order at the time, not a year and a half later.
Thank you, counsel. We thank you both for your arguments. The court will take this matter under advisement and issue a decision in due course. Court is adjourned.